It is June 6th of 2026, and this is the Court Gallery. Today, a defendant is popping hot for the whole pharmacy while pregnant. Another violates the no contact order while wearing a GPS tether and gets an ultimatum from the judge, "You have got to hear to believe." And a woman who embezzled from the American Legion finds out her sweet deal has finally expired after she disappears for months. From failed drug tests to unbelievable excuses, these defendants' sweet deals ended on sour notes this week. We'll see Webster, Satterfield, Aquilina, DiSanto, and Middleton from the gallery today, and it all starts right now.
What is your name, please?
Mackenzie Force.
Very well. We are on the record in GW 2024 CR 180, State of Kansas versus Mackenzie May Force. County Attorney Jill Gillette appearing for the state. The defendant appears in person, in custody, and pro se. Ms. Force, you are here on a motion that was filed May 22nd of this year to revoke your community corrections assignment. You should have been served with a warrant to show cause why that assignment should not be revoked. But I will go over the allegations with you nevertheless. In the warrant to show cause why your correction should not be revoked, the state is alleging that you violated the condition of your assignment that was to obtain and work faithfully toward suitable employment and support your dependents. In violation of that condition, the state alleges you failed to obtain suitable employment. Violation 2 alleges that you violated the condition not to illegally possess, use, or traffic in any controlled substance, narcotics, or other drugs as defined by law, except as might be prescribed by a licensed practitioner, and in that event, you would provide documentation of prescriptions. Specifically, the state alleges that on May 8th of 2026, you submitted a positive urine sample for methamphetamines and fentanyl while you were currently pregnant. I'm sorry, this is not Miss Denny, this is Miss Force. How did this? Just a moment. Jordan, okay. Let me call up yours. I called up the next defendant, Miss Force. I must have clicked on the wrong name. You are Mackenzie May Force, and you are here not on a, well, yes, you are. You have been convicted in May of 25 for various drug charges. And your warrant to show cause alleges that you violated the agreement not to enter, participate, or that you were to enter, participate, and successfully complete Senate Bill 123 treatment. And the allegation is that you were allowed a pass from treatment for Easter and returned to the KISA Treatment Center the morning of April 6th, 2026. Strike that. Let me try again. You were allowed to pay a pass from treatment for Easter to return to the KISA Treatment Center the morning of April 6th, but you failed to return as directed. And apparently a warrant had to be issued to locate you and you were allegedly arrested April 29th and transported to the Greenwood County Jail June 1st of 2026, and it is now June 2nd of 26. So, Ms. Gillette, the state is pursuing a motion to revoke community corrections based on those allegations. Is that correct? That is certainly what it would appear to be. So, Missy, do we have a date available with her sentencing judge?
Yes, this is Judge Satterfield's case, and she can hear it actually June 4th at 10:30.
All right, you will reappear June 4th at 10:30 before Judge Satterfield. You must be present in the courthouse, not by Zoom, but live at the courthouse. And Judge Satterfield would have set your bond in this matter when she issued the warrant. And that will remain the order of the court.
So it's 2 p.m. So it's my birthday.
Deputy, are you showing that her current bond is only set at $5,000?
Yes, Your Honor.
All right, well, that's what Judge Satterfield set it for. It looks like pre-sentencing was a 12.5, but you're at 5,000. Ms. Gillette, any reason to modify that?
I just asked that it be set where Judge Satterfield sat it.
And that will be the order of the court then. $5,000 cash or surety to reappear before Judge Satterfield in person at the courthouse June 4th at 10:30. All conditions will continue. Ms. Ford, are you allegedly pregnant at this time?
I have no idea. I don't know because they took a urine sample at Harvey County when I got arrested the 29th of April. I got arrested the 28th, but I went to Harvey County the 29th. And they took a urine sample. I don't know if they tested it for pregnancy and that came back positive or negative, but I haven't had my my menstrual cycle in like 2 or 3 months.
All right, well, just I hope you understand how important it is that you know the circumstances and follow up with any medical care you or your prospective child might need, and that you certainly not be taking the drugs that they've alleged, the fentanyl and the meth. But that's for you and your doctor to talk about. In the meantime, I need to find out if you are going to use a court-appointed attorney or hire an attorney.
I would like to use a court-appointed.
Okay, are you employed at this time? Do you have a job?
I am currently working on that. I've been in custody or at treatment since December 17th, and then I got picked up like 2 to 3 weeks later after I did not complete treatment. And so, I mean, I've been in custody with Martin County and Harvey County since December 17th of 25. So when I get out, I'm gonna maintain to go back to Harvey County and get my job reinstated back at Sonic in Newton, so I can start paying all my fines and doing all the things that I need to do.
Very well. But at the time, you're not employed. And at this time, I will find that you qualify for court appointed. I'm going to reappoint Attorney William McClendon, who handled your case initially, if he's able to take that again. So you might try to call him your first opportunity and get situated before you see Judge Satterfield on June 4th.
Okay, thank you, Your Honor.
You're welcome. We'll be in recess on your case. You're remanded to the custody of the sheriff at this time.
Denny.
Okay, bringing up Miss Denny now.
All right, we're gonna go on the record in state of Kansas versus Mackenzie Force. Actually, she's at the Greenwood County Jail, so that's why they're doing it for. Apologize. The state appears by and through the Greenwood County Attorney, Ms. Gillette. Mr. McClendon is court-appointed counsel for Ms. Force, and he appears separately by Zoom. Mr. Ketley is present with the Community Corrections, 13th Judicial District. A warrant to show cause was filed in this matter. And then the county attorney filed a motion on May 1 of 26, alleging and confirming that in support of the motion, the allegation is that the probationer, Ms. Force, failed to complete the special condition for community corrections, which was she was allowed to pass from treatment for Easter and was to return to KISA Treatment Center the morning of April 6, 2026. The defendant failed to return as directed. So, Mr. McClendon, have you gone over the allegation with your client?
Yes, Your Honor, I have, and we would stipulate to a finding of violation of probation.
Okay. I show that she was sentenced on 7/17 of 25. I do not show a prior revocation hearing. Ms. Gillette?
Your Honor, yes, I believe she's stipulating and waiving to the violations. In Harvey County, her probation was reinstated with the following conditions. She served a 30-day jail sanction there. She was to reapply to recovery court. It's their drug court. And if accepted, she had to complete it there. She needed to complete a mental health evaluation and complete a new substance abuse evaluation and follow all conditions of her recommendations in her evaluation. Mr. Ketley and I are recommending a 2 or 3 day jail sanction for our case, and that she be reinstated and needs to follow also the conditions of Harvey County Court. I know some of the judges don't like recommending the drug court. If not, I would just ask that she follow at least 1, 3, and 4. If the court was inclined to have her complete the drug court or recovery court program there, we'd also ask for it to be a condition. Those are the state's recommendations at this time.
I don't know who doesn't like to recommend the drug court, or I think there's a question about ability to order it in for another jurisdiction, but more importantly, I think there's always a concern if there's a violation that occurs in that drug court as a condition that they've created as part of the drug court. And the venue has not been changed, because you don't change venue in criminal cases. And it's not made part of the conditions at the time of sentencing. Is there an issue with violating them for not doing some part of the drug court? But I don't know. I mean, we've been doing it. It seemed to work. I try to keep an eye on it when we have revocations to see what the specific revocation is. And rarely do we have just one violation anyway. Most of the time it's numerous violations that include usage and other things. Not just something done during the court itself. But at any rate, all right. Anything, Mr. McClendon, that you would like to add?
No, Judge, I just have follow the state's recommendations. Ms. Force has been in custody since June 1st over here, so she's at about her 2 to 3 days. So I'm not sure if the state's wanting an additional 3 days or not, but I'd ask that be taken into consideration as well.
Okay, my question is she done her 30 for Harvey?
Yes, I have.
Okay. Well, I do not give 2-3 day sanctions retroactively. I do not do jail credit for sanctions. So it starts at the time that I impose it, which would be today. What's today? Today's Thursday, Friday, Saturday. So what? It's a difference of whether she gets released Saturday or Sunday, whether it's 2 or it's 3.
Sounds about right, Judge.
Okay. What is the plan with her with reinstatement as far as where she's gonna go? Treatment? She's gonna go back to Harvey County, I assume.
That is correct, Judge. She has she's going to play a mental health evaluation, a drug and alcohol evaluation, try and get re-enrolled in treatment and complete Senate there. I think she was reinstated for 18 months on probation back over there for similar
Okay.
charges. So that's kind of her plan.
Okay. Mr. Ketley, does she need an extension on this case?
She's set to be off in January. I think if it gets to the point to where she still has other things to complete, I can extend her at that time.
Okay. Ms. Forrest, is there anything that you want to say?
So I have a cash only bond in Martin County that's for $303. I'm gonna go finish here for that case. If I do, I will let Ed know that I'm going to Barton County. When I do, I will call him right away. I usually, when I went to treatment, I called Ed right away to let him know that I was going to KISS and released from custody. So I will let him know whenever I am released that I'm heading back to Harvey County. And I have to report to Gina Gady, which is my drug court officer, within 24 hours there.
Okay. Is she a community corrections officer too? Yeah.
Yes.
Okay. All right. Very good. All right. Thank you. All right. I am going to impose a 3-day sanction. Starting today, and then I'll release and reinstate you on community corrections to complete your conditions of community corrections and all conditions in Harvey County. Have you even started your GED?
Yes, I have been doing classes with K through 12.
Okay. And then what about MRT? Are you not far enough along that you've started that yet?
I still in phase 1 for drug court because it restarted. So I'm gonna ask the judge for that to be a condition that I start MRT. I did start CCRT though.
Okay. All right, well, let's try this again. You do understand though, I don't know about Harvey County, they gave you 30 days, but I am only required to give you 1, 2, or 3 day sanction. And then you can be ordered to serve your underlying sentence, which is probably about 15 months with the Women's Correctional Facility. Okay?
Yes, Your Honor.
You do understand that. Okay. So that was an error of judgment. That was very poor judgment for you not to return. You can move forward and successfully complete your corrections. I think you've got the support of Senate bill, you've got a drug court, you've got, enough there that if you want to succeed, you can and you will. But if you don't and you're back in front of me, then the option will be to send you to the correctional facility. Okay? All right, good luck.
Thank you, Your Honor.
We are adjourned. Anything further? I'm not going to assess additional fees today.
Yeah.
And I hope she gets that GED done too. But is there anything else?
Not for me, Your Honor.
All right, we are adjourned.
Yes, Your Honor. Sit right there.
Okay, are you Jordan Denny?
Yes, sir. Or yes, ma'am.
All right, we're on the record in GW 2024 CR 26, State of Kansas versus Jordan, Alicia Denny, County Attorney Jill Gillette for the state. Miss Denny appearing in person and pro se. Had quite a history in this case, Miss Denny. It looks like, though, ultimately you were sentenced by Judge Crum on October 9th of 24. He assigned you to, it looks like, probation, reporting probation. And it looks like now you're here on a warrant to show cause why that probation should not be revoked. The state is alleging that you violated the condition to obtain and work faithfully at suitable employment and support your defendants. The allegation is that you have failed to obtain suitable employment. The state also alleges that you violated the condition that you were not to illegally possess, use, or traffic in any controlled substance, narcotics, or other drugs as defined by law, except for prescriptions, and then you had to provide proof of prescriptions. Further, it's alleged that on May 8th, 26, you submitted a positive urine sample for methamphetamine and fentanyl, and that you're currently pregnant. And then it's also alleged that you were ordered to enter and participate successfully and complete a Senate Bill 123 treatment, but that you failed successfully to complete that treatment. So Carrie Ashenfelter of Community Corrections, your intensive supervision probation officer, is alleging these violations. So we need to set these back before your sentencing, Judge Crum. Do we have a date for her show cause, Missy?
June 11th at 9 a.m.
June 11th, 9 a.m. before Judge Crum. You must be present in person and not by Zoom, but in person at the courthouse before Judge Crum, June 11, 9 a.m. Judge Crum set your bond at $20,000 cash or professional surety, and I will maintain that bond. Now, when you were here for preliminary hearing, June 28th of 2024, you were pregnant. Are you pregnant again?
So I am not now, no. When I sent that positive UA, I found out that I was pregnant at that time. But it wasn't for very long at all. And once I found out that I was pregnant, I completely did stop again, and I even asked to go back into treatment again, but I don't know. I wasn't very far along at all. And I guess the stress of me trying to get off drugs again or what. I also have problems with with my last son. I actually, something with my ovaries, I have a problem with one of my ovaries working, and especially when I have cortisol going through. It's just, yeah, it's really hard for me to maintain being pregnant anyway now, especially with my last labor and delivery. So when I found out I was pregnant and I had just taken that UA, I immediately tried to get clean again, and yeah.
Okay, so you've had 2 pregnancies during this case, and one of them was unsuccessful. Were you able to deliver either of the children alive?
My son is alive, yes. This one, I wasn't very far along, so I had to go to the hospital, and they, yeah.
Okay, well, all right. Well, I'm sorry that you're going through that, but you know, you might want to talk to your attorney and your doctor about possible effects of fentanyl and methamphetamines on pregnancies and the unborn, but that's not to be, we don't need to address that any further today. But
Yeah, as
just,
soon as I found out I was
Okay, well-
pregnant, and that I was right after I had taken that UA, so.
okay, all right. Well, I won't prolong that on you anymore today. I just want you to be more careful of your health, and I want to make sure the jail is able to tend to whatever medical needs you have today. Have you had any problems with your medical care at the jail there?
No.
Okay, all right. Deputy, does the jail have any concerns about her health right now you need to bring up or want to bring up?
Not that I'm aware of, Judge.
All right, thank you, sir.
I'm supposed to be taking my Suboxone or Subutex. I don't know if you guys do it here. Yeah. But yeah.
Okay, well, thank you for bringing that up. I don't know much about that drug, but I'm sure the deputy can talk to their nurse and see if there's something else you need. I know they try to take good care of their
Yeah.
inmates.
Because after my UA, my positive UA, and I went to the doctor, because I was trying to get into treatment again, because obviously I wanted to be able to have a safe pregnancy. I wanted to get back. They put me on Subutex to get
Okay.
to make for everything to be healthy, but before that could even happen.
You had the other misfortune. Okay, well, deputy, I'm sure you'll talk to your nurse and get her whatever care she might need.
Yes, ma'am.
Thank you. All right, so let's talk about your legal issues here with the warrant to show cause. Are you going to need to reapply for court-appointed attorney, Miss Finney?
Yes, please.
You haven't been able to work in a while.
I was just working, but with my IOP, I had corrections, and then I also had another class that my corrections officer, two classes that my corrections officer wanted me to do throughout the week. My job told me that I had too many things going on during the week, so I was trying to find a different job that would allow me to do everything that I was supposed to do.
Okay.
And yeah,
But you've been unemployed for a little while now.
just a little less than a month now.
Okay. Well, I'm going to reappoint Mr. McClendon to your case. So contact him as soon as you're able, and we'll get him over there to talk to you and get you ready for this warrant to show cause hearing before Judge Hart on June 11th.
Okay.
And in the meantime, your bond is set by I'm sorry, I said Judge Hart, Judge Crum. And Missy, did you say you're putting that in front of Hart or Crum?
From
Okay, thank you, Judge Crum. You need to be back here live in front of Judge Crum June 11th at 9 a.m. on your warrant to show cause. So make sure you get with Mr. McClendon as soon as you can so he can start helping you prepare your response to those allegations. And in the meantime, your bond will be maintained at $20,000 cash or professional surety, and you can address that with your attorney as well. And see if there's any chance he can get that hearing moved up before Judge Crum. Sometimes judges can move those up, sometimes they can't. But you know how to get a hold of your attorney?
I can you guys have his number?
Yeah.
Yeah, I can get his number.
All right. Okay. Anything else, Miss Denny?
No, ma'am. Thank you.
You're welcome. Miss Gillette, anything else?
Nothing from the state.
All right, we'll be in recess. Miss Denny
Thomas.
is remanded to the custody of the sheriff. Who's the next one, deputy?
Just have a seat.
You are Simon D. Garza, is that correct, sir?
Yes, Your Honor.
Very well, we'll be on the record in GW 2026 CR 89, State of Kansas versus Simon D. Garza, County Attorney Jill Gillette for the state. Defendant Mr. Garza appears in person and pro se. This is first appearance on the sole charge of interference with law enforcement, obstructing, resisting, or opposing a felony warrant, service, or execution.
Okay.
And that charge, sir, is filed as a level 9 non-person felony. It alleges that you resisted or opposed law enforcement while they were trying to serve a felony DOC warrant, that you did so by refusing to open the door of the residence, not responding to officers to show yourself, and hiding behind a barricaded door under a pile of clothes and 2 framed canvases in a closet. As a level 9 non-person felony, your sentence Okay, your sentence could be anywhere from 5 to 17 months in the Department of Corrections, and your fine could be up to $100,000. This could be concurrent or consecutive to anything that you might have going on through another case with the Department of Corrections. You do have the right to a preliminary hearing, and we will set that, but you also have the right to an attorney. Do you want to hire an attorney or apply for court appointed, Mr. Garza?
I'd like to apply for court appointed, Your Honor.
Okay, are you employed at this time?
No, Your Honor.
How long have you been unemployed?
I do handyman work, so probably since I got arrested on this case, May the 5th.
All right, and with the handyman work, is it just as needed?
It's
Somebody
just
might need it. It's not a steady.
Whenever I get a job,
Okay,
it's not all the time.
okay. All right, do you have any money available to hire an attorney? Anything in savings, CDs, anything like that?
No, ma'am, I do not.
All right, at this time, I'm going to appoint an attorney. Missy, we don't know who that'll be yet.
Nope, not yet.
And when do you want him to call you and find out who his attorney is?
Friday.
Check back with Missy, my assistant, on Friday, and she will tell you who your attorney is and how to get a hold of the attorney, Mr. Garza.
Yes, Your Honor.
Next, we will set your preliminary hearing control. This won't be your actual evidentiary prelim, but it'll be a date to give you and your attorney a chance to decide if you want an evidentiary hearing or if you want to waive it, and you'll tell me at this next hearing. So, Missy, when is that?
July 17th at 1:30.
July 17th at 1:30. That's about a month and a half away. You can talk to your attorney and see if that can be moved up or not. Then the final issue we have to talk about is bond. Looks like you have a $20,000 cash or surety bond set. Where do you live, sir? What town?
Eureka, about 3 blocks away.
Okay, Eureka. And you don't work, but you do handyman services. Ms. Gillette, anything to say from the state on bond?
Mr. Garza is kind of known to the state. He's been here quite frequently. We've had to go get him several times. So I would request, on this case, with it just being interference with a law enforcement officer on felony, $7,500 cash or professional surety.
Mr. Garza, anything you want to say about that bond?
I missed it, Your Honor.
She recommends $7,500, taking into consideration some of your history, which as I look at your history on Odyssey, you do have quite a bit dating back to an aggravated assault and violation of protection order 2005. Yeah.
I was originally. Oh, sorry, I didn't mean to interrupt.
You've got quite a few things here. I see in 2007 there was an ag robbery. Looks like that was dismissed, perhaps. Then in 2007, a burglary that you pled guilty to and a theft. Disorderly conduct, guilty plea. Another burglary in 2007 dismissed. Got some civil matters there. 2009, some drug charges and a domestic battery. Another domestic battery, and violation of protection order. In 2010, you had a list of charges dismissed from burglary to multiple thefts and another burglary. Oh, it looks like there was some plea negotiations going on with some guilty pleas for theft, multiple thefts. 2011 habitual violator conviction. 2013 unlawful cultivation or distribution of controlled substance, ag weapons violation by felon, and an unlawful possession of controlled substance conviction. 2017 conviction for driving while suspended. 2019 aggravated battery dismissed, but criminal restraint guilty plea conviction. 2019 driving while suspended second or subsequent conviction. 2020 an aggravated battery guilty plea conviction. 2011, a list of drug charges, domestic battery, criminal property deprivation. Looks like some of those were dismissed for plea and some of them plea agreements. Some of them you could plead guilty to, like a criminal threat, a criminal possession of a weapon by a felon firearm. Violate offender registration, theft by deception. 2021 violation of the offender registration. 2021 possession of hallucinogen. Twenty-three more felony drugs and opposing or resisting a felony arrest. Possession with an intent to use drug paraphernalia. Do we still have pending this 2026 Greenwood County criminal littering of private property? That's not this one. Is when is that set for?
It's on the misdemeanor docket because he has a misdemeanor attorney.
Oh, okay. That's the one where he reportedly was dumping property on people or trash on people's property. Did he just miss a court date for that, maybe? I kind of remember something about that. Okay, so that's a misdemeanor pending. Have you been to court on that yet, Mr. Garza? Do you know anything about that?
Yes, I've been to court on that, and you set it for the 7th, I believe, Your Honor.
Okay, thank you. I didn't
Or
remember.
8th. One of the two.
Sometime in June yet? Okay.
This month.
All right, so we've got that pending, but that's a misdemeanor, so those will probably be on different dockets. And then we have the case we're here on now. So Mr. Garza, you've got quite a history here. You live here. How long have you lived in the county?
I've lived in the county 4 years, in the state 50.
Okay. Are you married or single?
I'm single and engaged.
Okay. Well, 20,000 with that history and the charge in front of me sounds pretty conservative, actually. It's a lot of money, but in light of everything we're looking at. But if there's anything else you want to tell me, I'd certainly consider it.
Well, I got arrested on this and booked on this and it was 5,000. I haven't violated on it, so I don't see why it should be that much. I mean, maybe meet in the middle.
Like 10,000 cash or surety, is that where you see the middle?
Yes, Your Honor.
One count of interference with the law enforcement officer attempting to hide and is the allegation in that history.
Yes, Your Honor.
We can revisit that at your next hearing, but for now, I'm going to leave it at 20,000.
Yes, Your Honor.
You be sure and call Friday though and find out who your attorney is. Your attorney can advise you about the bond issue as well as the actual charges and possible outcome. All right, so if there's nothing further, we'll be in recess. You are remanded to the sheriff.
I missed the
Gordon.
last part, Your Honor.
I said I told you a couple things. You can revisit this with your attorney and we can talk about it at the next hearing. And to call your attorney can help you with the bond as well as the charges. And for now, I'm going to send you back with the deputy with your court date set July 17th at 1:30.
Yes, Your Honor.
All right, thank you, sir.
Thank you.
You're welcome.
And that was a $20,000 bond?
Yeah, leaving that at 20,000 cash for professional surety.
Okay.
Record. This. All right. This is docket 21898 FH, People of the State of Michigan versus, is it Letitia?
Yes.
Monica-Marie Wells. Counsel, your appearance is for the record.
Good morning, Your Honor. APA Burbucks on behalf of People for Michigan.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the perjury?
Yes.
Thank you. Put your hand down. Ma'am, you were on bond conditions, and this is an old file. And you failed to appear a number of times since 2021. And now you were picked up on a bench warrant that I've had outstanding since December 20th, 2021. And it reads, defendant tested positive on November 22nd, 2021 for methamphetamine. Defendant failed to drug and alcohol test on November 29th, 2021, December 11th, 2021, December 13th, 2021. I think this should be amended to say that she also failed to report for pretrial services monitoring since 2021. Would that be also accurate?
Yes, sir.
So I'm going to also add that. Otherwise, they might try to violate you again. So defendant failed to appear for pretrial services since or about I was going to put since on or about December 16th.
Did you say December
16th, 2021. And anytime thereafter. And you are entitled to an attorney. Would you like me to appoint you one?
Yes.
All right. And we're going to reset this, okay? Is that a yes?
Yes.
Okay, so we'll go through all your rights and everything then. But you do have a right to an attorney, you have a right to a hearing. This is by preponderance of the evidence. You have a right to cross-examine any witnesses and evidence brought against you. You have the right to choose to provide a defense, but you don't have to. If you want any witnesses present, the court would order those witnesses to be present. If you remain silent, your silence cannot be used against you. If you want to testify, you certainly can. The people would be able to cross-examine any witnesses, evidence, and yourself if you testify. In a violation of this kind, it's not beyond a reasonable doubt, as it is with your charge of count 1, controlled substance possession of methamphetamine. That is a 10-year felony and or $15,000, and there could be license sanctions. Now, that you are presumed innocent until proven guilty beyond a reasonable doubt, and on a violation of bond conditions, it's by preponderance of the evidence, which means more likely than not. Do you understand all of that?
Yes, ma'am.
All right. So I'm going to remand you to jail until we have this hearing. I'll give you a date in a moment. We're going to appoint you a public defender to represent you. Ma'am, it looks like you have a long history with meth. I don't know what other drugs you're using, but in regard to the jail, do you need to be treated? Are you going to be going through withdrawals or anything? I want to make sure that jail is put on alert and it has medical available for you.
They have me at Suboxone.
Okay, so they're monitoring that?
Yeah.
Are you doing okay?
Yeah.
Being on that medication, do you understand everything I've said?
Mhm.
Is that a yes?
Yes, ma'am.
Okay, so I'm gonna keep you there for your own safety and continue treatment, and we're gonna get you a lawyer, and you're gonna be back in front of me. Is that okay?
Yes, ma'am.
All right. Do we have time next Wednesday? I'm just gonna put for Wednesday at 11:45. And that's June what?
That's June 10th, Your Honor.
June 10th. All right. And then if the lawyer wants to change it, or we need to change it to another day, we'll let you know, but June 10th at 11:45. Okay?
Okay, thank you, ma'am.
And we'll put a note that you should continue with the Suboxone and having medical see you. All right, thank you. All right, this is docket 256822. People of the state of Michigan versus William Webster Crossing. Counsel, your appearance in the record.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Mr. Krosky. He is standing to my right.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide is true, the whole truth, and nothing but the truth of the mental perjury?
Yes, sir. Yeah.
Thank you, sir. Put your hand down. Have you taken any medication yesterday or today?
An antibiotic.
And is it anything that would interfere in your ability to understand the court or your attorney?
No, ma'am.
Okay, is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, I have.
And sir, you were on bond conditions. Part of those bond conditions were that you not have any contact, directly or indirectly, with your third party, with Chelsea Christine Shannon. And I have a bench warrant after receiving a pretrial services report. Counsel, I take it you have reviewed that.
We have, Your Honor. Thank you.
And it reads that you should be held in contempt because you assaulted Chelsea Shannon and you had direct contact with Chelsea Shannon. There are 2 alleged violations. Sir, well, let me ask you this, counsel, are you waiting for the arraignment?
We wait for the arraignment, Your Honor.
Sir, I can't proceed with these. I'm just arraigning you and telling you why you are back in that jumpsuit. And that is because your right to remain intact. In that case, I don't know where it is. It could be dismissed. You could come up here as a second file. You would have a right to a presumption of innocence until proven guilty beyond a reasonable doubt on that. On the bench warrant, it's by preponderance of the evidence, so more likely than not. If you pled to these today, it would be interfering with your rights. So I just need to arraign you, and then we need to talk about bond. Correct, counsel?
Thank you, Your Honor. Yes, Mr. Krosky is going to be entering a plea of not guilty to the allegations, and respectfully, we would request a contested hearing. Thank you.
And that will be as we Bring up this other file. Where is that file?
It's pending before Your Honor. We had a pretrial on
Is it
it.
right here?
Yes.
Okay.
Thank you.
And so you had a pretrial on that as well as this?
Yeah, we had a previous pretrial, Your Honor, and I'll pull up the file here.
Okay, can you, they didn't put both files on here, so can you tell me both, file numbers? I have the 6822, do you know that number?
That's the correct number, Your Honor. It's
That's-
25006822. I believe they'd also included the district court number.
That's this file here.
But Your
There's
Honor,
a new file. Is there a new file?
not to my knowledge, Your Honor. He only has these.
So there's not two files.
There's not two files. There's only one file, Your Honor.
So it says he assaulted her.
Correct.
Are the people issuing new charges?
So it looks as though those charges were dismissed because we did not believe that it looks as if we would not be able to meet the burden by beyond a reasonable doubt. But obviously the improbable cause for the PA 53. So I would also be requesting a contested hearing at this time.
Well, the assault, I'm striking that. The only thing pending now before this court is that he had contact with her.
Thank you, Your Honor.
So,
Yeah, Your Honor, we're scheduled for final pretrial on June 24th, and then we have a jury trial date of August 14th on this matter.
okay. So we're going to also schedule this contested bench warrant and have a global resolution or not on all of this, and we'll figure out what's going on with this. And then you can have your hearing, and then if we need to go to trial, go to trial. That's fine, but we can deal with this. On the 24th, is that acceptable?
Please, Your Honor. Thank you.
All right, so I imagine now you're going to ask me for bond.
Yes, Your Honor. Thank you.
Make your record.
Thank you. Mr. Krosky respectfully requests an interim bond while these allegations are pending. He has a stable place to stay. He has a job. He would respectfully request an opportunity to get back out so he can keep his job. It's been a struggle for him to maintain employment. He finally has a good, stable job. He's not a flight risk. He has connections to the community. And if Your Honor gives him another opportunity here, he'd make sure that he complies with all Your Honor's orders. Thank you.
Tell me about this address. Is that in 3700 Berwick?
That's correct. Yes.
And who lives there?
That is my sister's home. My grandparents passed away and left the house to her, and that's where I lived with them.
Excuse me. On behalf of the people, what would you like me to know?
Your Honor, the people are concerned that Mr. Krosky is having contact with the exact victim in this case. Not only had contact, but had contact that resulted in police contact, Your Honor. The people are concerned that Mr. Krosky is a danger to himself as well as the victim in this case if he's let out. We have this evidentiary hearing on June 24th. I believe it'd be appropriate to hold him at this time with a cash surety bond up until the time of that evidentiary hearing, and we can address bond at that time.
Was he on Tether? This last one I gave him was he was not any longer under house arrest, but it was jail GPS with victim notification. What happened to that? Did I take it off?
No, Your Honor. He was wearing the tether at the time. Correct. You still had the tether on you. Yes.
So you're wearing the tether and you still contact her allegedly? There's different considerations for bond, and that would be safety of the victim and safety of the public. So I did what I could do in terms of the GPS tether, and I still got a problem in front of me. That's a problem. What would you like me to know, sir?
Won't be a problem anymore. There won't be any more problems out of me. I've sat in there and watched people in there. There's this guy in there, 60 years old, doing the same things and everything I'm basically going through, and I don't want to be that person. I just want to cut off the record.
Do you have children in common with her? No. Have you ever looked to see how many women there are in the world?
Yes, ma'am.
How many?
Too many to be dealing with stupid
Billions.
stuff.
Globally. Do you need this woman in your life?
No, Your Honor.
Do you have a power and control thing over her?
No, Your Honor.
She doesn't want to be around you. Every time you get near her, there's a fire. Not in a good way. Where are you working?
Applebee's.
How far is this Berwick Drive address from where she lives?
I'm not sure.
Do you know where she lives?
I believe it's on the north side of town.
Is there any reason you need to have contact with her?
There's none, no, Your Honor. There will not be.
Well, here's the thing, sir. Your rights remain intact and we're going to trial in August. I don't know what the plea offer is going to be. I don't get involved in any of that. So just let me remind you, we have an aggravated domestic violence, which is a year misdemeanor. We have an allegation of assault with intent to do great bodily harm, less than murder, or by strangulation, which is a felony punishable by 10 years. You have a habitual offender's second offense notice, so that 10-year becomes 15 years. So if you want to go to prison for 10 and 15, we can put you to work in the kitchen. You must have some experience. I got some pretty good food over at Applebee's. So you got to decide if you want to be a server at Applebee's and a free man, or you want to be working in the prison kitchen. Yeah, you can answer it.
I want to be at Applebee's.
I like it to get Applebee's. I like good servers. You make decisions to make. She does not exist in your world. How long did you date her?
A year and a half.
You got pictures of her? You get rid of all of them?
I lost my phone, so I don't have anything for that.
Well, it's up in the cloud swimming up there somewhere, isn't it?
Yeah.
If you miss her, or you want to remember what she looked like, look at a picture. That's as far as you're going to get. Because if you get any farther, we got a lot of prisons in this state. And I know the wardens, and I'll make sure they have a bed for you. Well, you haven't gotten in yet, but I don't know that I should give you another chance, sir. You talked to all those other sad sacks I got over there who are doing the same thing as you? Most of them are staying in. Tell me why I should let you out.
I believe let me out this. So
Here's the problem. And I tell my students this all the time. I deal in evidence. I don't believe, or when you say I believe, I tell the lawyers, say he believes the church got evidence. So I don't care what you believe, and I don't care what you think. I want evidence. I want you to give me some actual sentences about what your understanding is and what you will do, not what you believe you'll do. Because when you believe something, that tells me, yeah, it might not be true. Got it?
Yes.
Okay, now talk.
I understand you're not playing with me.
I'm not.
And I understand that if this happens again, if by any means or anything like that, I'm going down. There's no compassion, there's no nothing. And I see it in your face, and I believe it 110%. I'm scared to talk to her. I'm scared to
talk to me.
That's why, because I don't want to go down by you.
I tell you what, you go on the internet, there's lots of pictures of me, some nice, some really mean. Maybe you should put one of those pictures on your phone. I mean, if you even think about talking to her, you look at my face.
Gotcha.
Okay. What's the next date? I'm sorry, Nels, you gave it to me, June 24th?
June 24th at 9 a.m. Yes, it's scheduled for final pre-trial.
All right, sir, I'm going to give you a $25,000 PR bond. I'm going to make a note. This is the last bond. See that note on the cover?
Yes,
Great. I don't play. Great. I don't play. At least I don't think nicely, maybe I should say.
And that there'd be a chance I'm not gonna miss it, so.
Hope not, ideal evidence, as I said. So you'll report your pretrial services as often as they want you to, you'll be placed on that or continued on that jail GPS. Tether with victim notification, and I write if it's possible, I believe they know where she is, but sometimes they don't, so that's why I'm writing if possible, it's mandatory if they know where she is. You'll not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. You'll show any prescriptions to probation within 24 hours, take any psychotropic meds as prescribed. You will test as requested by pretrial services law enforcement, any court officer or your sister who you live with. You will not own, have in your possession or under control weapon, gun, ammunition. You'll not be in the presence of anyone who owns those or has those items. You will maintain that residence that you gave me of your sister, and you will continue being employed. If you, at any time or not, you're going to be part of a work seek program. Maybe you have to think about working some overtime.
That's all.
So you don't think about this. Maybe you'll meet a nice girl in Applebee's. You'll appear for all hearings and proceedings. The next one's June 24th at 9 a.m. Anything else I need to address?
Hey, Your Honor. No, Your Honor, thank you.
Have I been clear, counsel?
Crystal clear, Your Honor. Thank you. Mr. Krosky, any questions?
No.
Thank
You understand what no contact means?
I understand it's nothing, or I'm going down and you're not playing with me. Don't talk to
No.
look, don't see if she's in my way, go the other way. If you call, I delete.
She shows up naked at your door, you don't open it.
I
you call
close that
911.
door and run to the basement and call 911.
Exactly. She shows up at Applebee's, you go to the back and you have someone else wait on her. You just take a break. No smoke signal, carrier pigeon, Hallmark cards, roses, nothing.
Understood.
Okay, it's all for the record. We'll get you a copy of this.
Thanks.
All right, this is docket 25-1992 People of the State of Michigan versus Michael and Trent Johnson. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bar Buxton on behalf of the people of the state of Michigan.
Hello, Your Honor. Stephen A. Freeman, Public Defenders, appearing on behalf of the defendant, and Mr. Johnson is standing to my right. Thank you.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth when it comes to perjury?
Yes, Your Honor.
You may put your hand down. Sir, you pled guilty to count 2 domestic violence and or knowingly assaulting a pregnant individual, third offense, that is a felony punishable by 5 years. You also pled guilty to count 6 stalking, the misdemeanor stalking, punishable by 1 year. Do you recall that?
Yes, Your Honor.
Have you taken any medication yesterday or today?
No, Your
Are
Honor.
you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And have you had enough time to talk with your attorney
Yes, Your Honor.
and review the pre-sentence investigation report?
Yes, Your Honor.
And on behalf of the people, any corrections, additions, deletions?
No, Your Honor.
On behalf of the defendant, corrections, additions, deletions?
Your Honor, I noticed on the very front page, on the one hand, it lists a number of convictions in the body of the report for my client, but then it said a prior felony 0, prior misdemeanor 0. If you could,
It says, let's see, we've got 10 out of 10, so it should have some.
I think it's 1 felony and 6 misdemeanors, unless counsel has a different.
I would agree so as well, Your Honor. That is what I
Right.
counted this morning.
I changed it to 1 felony and 6 misdemeanors. Thank you.
Nothing else with respect to the body of the report. Thank you.
All right, I changed that. Does that change the guidelines? Or just
The guidelines were properly scored with those numbers. They just
Okay.
didn't make it to the front page.
Okay, thank you. I made that correction. I appreciate you clarifying that, counsel. Is there a victim here who wishes to address the court?
No, Your Honor. And there is no corrections from the people in regards to any of the guidelines.
Thank you. And what would you like me to know?
I don't know if defense has
I
any.
think he said no. Counsel, do you have any corrections to the guidelines or anything else?
I have two
Oh, you do?
corrections, if I may.
You may.
Thank you. First of all, I'm in agreement with the prior record variable scoring, 45 points at PRV level D. I believe that's accurately scored. On the other hand, offense variable 3 is currently scored at 10, and I think it should be scored at 5. The rationale being 10 points is awarded for bodily injury requiring medical treatment. And I'm aware of the note that says requiring medical treatment refers to the necessity for treatment and not the victim's success in obtaining treatment. 10 points is awarded on our report here because the author of our report stated that LFD was called and suggested that these two persons get additional medical care. But my objection is as follows. If I'm a paramedic on one of those LFD rigs and I see someone who is in need of medical attention, I'm not going to ask, do you want to go? I'm going to get them stable, get them in the rig and get them to the hospital. The second thing is the note says, refers to the necessity for treatment and not the victim's success in obtaining it. In other words, it sounds like a victim tried to get medical help, but failed, but should have received it. And so I think it's only 5 points.
I don't think she has to seek it, even then. I think it should still be 10, but I don't know. We have
That's my understanding as well, Your Honor, is that she does not actually need to. As you stated, requiring medical treatment refers to the necessity for treatment and not the victim's success in obtaining that treatment. That's under MCL 777.33 subsection 3. So it does not matter whether she got medical treatment or not. The fact that they evaluated her and recommended that there be medical treatment is enough for the people for OV3 to be scored at 10 points.
Yeah, counsel, I think your argument's valid. They worded it poorly, but she wasn't denied medical treatment. She simply chose not to go, and that's what it's speaking to, that she can choose not to go. So it's 10.
I was keying on the keyword requiring, Your Honor.
Yeah.
Bodily injury requiring.
Well, she was strong, and just because it's required, and many people would go, she chose not to for whatever reason, and could be any multitude of reasons, but and I've heard this argument many times. I believe it's 10, and it's been upheld, and case law speaks to that. But if not, that's an appellate issue.
Thank you, Your Honor. My only other objection is to offense variable number 9, currently scored 10 points. I believe it should be 0 points. And the reason is because we award points for persons who are put in danger of physical injury or death. And we, as the author of our report said twice in the body of the report, we don't score for misdemeanors. We are scoring for the felony conviction of domestic violence, third offense. That involved Alyssa Mix only. The other individual, Mr. Dexter Jones, my client's brother, he was not involved in the domestic violence third offense and should not be included as a victim. I understand the thinking of the probation department, but I do not believe it's accurate in terms of following the instructions. We're just scoring the domestic violence, and she's the only person in that charge who was in danger of injury. So I think it should be 0. Thank you.
Counsel?
Your Honor, there was a charge of assault and battery in regards to the other victim, Mr. Dexter Jones. It was ultimately dismissed as part of the resolution in this case, Your Honor. So I do believe that there were 2 victims as a result of this overall case. So I do believe that OV 9 should be scored in 10 points.
We made our record over 9 is 10. Thank you.
Thank you, Your Honor.
All right, and we have some people. What would you like me to know?
Yes, Your Honor. I asked that you follow the Killebrew agreement in this case to a county cap. I believe, given Mr. Johnson's criminal history and in regards to his interactions on that night, I believe it to be appropriate. Thank you.
Thank you. Counsel?
Yes, Your Honor. Thank you very much. Of course, ultimately, I am going to be moving the court to sentence my client in accordance with the agreement that we had in terms of the punitive aspect. But also, there's something else that's troubling, and it's not the first time it's come up. I don't have a specific answer. I just want to raise the issue, if I may. We have an individual here, and it's because I work with the Public Defender's Office. Who do we represent? The homeless, the unemployed, the mentally ill, the persons who are addicted to drugs or alcohol or something. And so a lot of the comments authored by that in the report, I'm not saying are wrong, but they seem to reflect intentional acts of failing to show up to probation at an appointed time and hour, or failing to do this or do that. I'm not talking about contacting someone that the court has ordered him not to contact. I know that that is going to be something on the court's mind in terms of imposing a sentence. But time and time again, the report is telling me, it said defendant's lack of overall support in the community. Well, then let's get him some support in the community. I don't know the job requirements of the probation, the parole office, or the pretrial services folks. I know we have 4 social workers at the Public Defender Office, and we try to address those kind of concerns. We're dealing not with people who have a cell phone. They don't have a wristwatch. They don't have permanent housing. They don't wake up in the morning like everyone else who walks into this room. And so I'm hoping that the court will take that into consideration, that yes, some of this behavior is absolutely criminal and should be addressed. But on the other hand, just like his involvement at the, what was it, he didn't leave the program. Probation was alerted that he had attempted to telephone his former girlfriend, this Miss Mix. That's what happened there. He did not purposely not take advantage of the program. So I would respectfully, on behalf of my client, urge the court to sentence him in accordance with the agreement and to no more than 12 months county jail. Probation, if the court orders probation, we've got to put a program together. We're going to put something together so he's not destined to fail.
Well, that's what probation is for, sir.
Yes. Thank you very much, Your Honor. That concludes my comments.
Probation apparently didn't read this. The agreement was up to 1 year jail, and then I guess probation, but they did recommend the prison sentence, but that's not, I would be violating the Killebrew. There's nothing here that tells me I should violate the Killebrew. Is that correct? On behalf of the people?
That is correct, Your Honor.
Okay, thank you. Sir, what was
I apologize, Your Honor. There is one thing. There was the violation that did occur. There was the bench warrant arraignment that he ultimately pled guilty to without a defense attorney. You had ultimately given him 7 days with 17 days, 17 days with 17 days credit. I did not have a copy of the police report at the time. I just wanted to put in what the victim had stated occurred, because obviously we only heard from Mr. Johnson. She had stated that during that incident, she was at that location with another male named Tasavion Mo Young, and she stated that the defendant had come around to the two of them approximately 6 times that night, and that she said he did not assault her, but had been harassing her over the course of the night, and that it was around 6 times that he had addressed her. Obviously, when the defendant pled guilty, he stated that he walked on them having sex. But the victim does tell a different story in the police report. So I just want to make sure the court is aware of that. Technically, that is a violation of his no contact order. He did plead to such. So if the judge, if your honor were to go beyond the Killebrew agreement, he would not have the ability to withdraw these.
Okay, so there is that. All right, thank you. Sir, what would you like me to know?
That I'm basically responsible for all my actions. I'm myself to say this. I'm responsible for all my actions, and yeah, I know I was supposed to be around it, but I still have. I do admit I was around her 6 times because I went to the store and came back and they have sex, and it did make me mad. I'm not gonna lie. It did make me mad. I didn't know how to handle it, and just one of the.
Well, what would you change if I gave you Groundhog Day and we got to repeat the day, right?
Yeah.
What would you change?
Not going around, staying away from her at all times. Every chance I get, go the other way.
Yeah. Is that going to be difficult for you to do?
Yeah.
Huh?
Say it again, man.
Is that going to be difficult for you to do?
No, like that.
So, is there another file open on that? Is there another file with this defendant?
No, Your Honor.
Okay, so the
other charges did not result in anything. Or
Okay.
the other incident did not result in any charges.
Okay, just making sure. So, do you have a child in common with Ms. Miggs?
Yes.
So, how old is that child?
He is 3. He's with her. If I'm not mistaken, he's with her mom's Spanish side of her family.
Okay, so neither one of you has the child?
Correct.
Have your rights been terminated? Is your name on the birth certificate?
No.
So you're what we call putative dad, and then the state will come in and terminate your rights, or what's the story?
No. So when she had our son at Sparrow, she got to hold him for at least, I believe, 2 to 3 minutes time, and CPS came in and took him, and we haven't heard nothing back yet.
How old is the child's 3 years?
3 years old. He was born January 18th.
Okay, that doesn't make any sense, sir. You're saying that when CPS came in at the time of the birth?
Because CPS came in and took our son because of the fact that she already had CPS, yes.
That's the law. So when you're terminating on other children, they take the other child, but you can show that you are a fit parent to keep that child. So neither one of you went through that process.
Yeah.
Okay. That's sad, sir.
Yes, yes.
You think you can stay away from her?
Yes, Your Honor.
Let me just tell you, if you don't, you're going to prison. I should maybe do that now. I'm not going to do it. But if you do poorly on this probation, you got some prison guidelines here, and I will send you there. Have you ever been in prison?
No, Your Honor.
Do you want to go?
No, Your Honor.
Well, you got the key in your hand. You want to unlock the door to prison. You have contact with her. You commit more crimes. You do some more things. That's what I may very well do. You stay in jail?
No, Your Honor.
Well, what are you going to change?
My life, Your Honor.
Probation is for your success. It is not a punishment. Jail or prison is a punishment. So you have to keep your word and change your ways. Otherwise, it's jail or prison. I'm going to make a note that I told you that. Now, Maybe you'll do something pretty minor and I will let it go, or probation will handle it. But one of the main reasons you would go to jail or prison is contact with the victims. More victims in your path. Do you understand?
Yes, Your Honor.
Great. You're gonna be on probation for 18 months. I'm waiving probation oversight fees. You have on count 2 and count 1. You will have 365 days jail credit for 61 days. The balance is held. Do you have an address to go to, sir?
Yes.
What is it?
415 West Kalamazoo Street.
Who lives there?
It's the City Rescue Mission.
Okay. So you're gonna go to the City Rescue Mission. You're
Yes,
going to, within 24 hours of your release, come back here and meet with probation.
Yes, Your Honor.
You will not use, possess, or consume any alcohol, illegal drugs, or drug paraphernalia. You will not adulterate any tests. If there's a positive test, there'll be a secondary test done so that we can see if it's a positive or a false positive. You will be part of a work seek program so you can get employed. Is there any reason you can't work?
No, Your Honor.
Why haven't you been working?
Been worried about my mom because she's getting to the point where she's kind of forgetting she's homeless and too busy worrying about her.
So where is she? Is she also at the rescue mission?
She's homeless too. She's home sometimes at the mission or sometimes at a friend's house or whatever.
You know, if you got to work, you could get an apartment for both people. Does that sound good?
Yes, Your Honor.
Well, there's also emergency funds, especially if she's ill. There's lots of things that you can do, but probation is going to help you with that. Okay, so I want you to be part of a work seek program. I want you to be gainfully employed and not give your employer any cause to terminate you. There are clothes and all sorts of things that are available that we can get you so you can go for an interview, you can get a job. And I'm going to put a note to probation that you should be provided services to find a home.
They can help you with this.
An apartment, something, okay? Maybe your mom can live with you and you can, I don't know if she gets Social Security or SSI, but maybe you can use those to get some kind of help for her or medication. I don't know. You need to reach out and get some help. Okay? You have siblings?
Yes, Your Honor.
Are they helping?
My sister works. My first, one of the other victims in this case is in prison. He gets out next year, and my other brother is also homeless.
Okay. So the sister who works, she won't fit you all up?
No.
Okay. Well, y'all need to get some employment. You and your mother, wherever your mother needs to hear. All right. You shall not have any contact with any known felons or anyone in the Department of Corrections. If you need to have contact with anyone like that, you need to let probation know so we can give you permission. You will, as I said, be part of that work seek program. Keep us informed of any employment that you do receive. You'll have no contact with Dexter Kermit and Alyssa Rose Mix. No contact means they don't exist in your world. No phone contact, carrier pigeon, smoke signal, Hallmark cards. You end up in the same shelter. You go to a different one. Okay?
Yes, Your Honor.
Once you have employment and hopefully you get a place to live, you'll allow probation into residence at any time for probation supervision without a warrant. And they will search your home, garage, cell phone, computer. All right?
Yes, Your Honor.
And so you should not have any drugs, illegal drugs, I mean, for any contraband, guns, ammunition. You understand what all that means?
Yes, Your Honor.
Okay. You can take over-the-counter medication. You can take less but not more. You'll not have any assaultive, abusive, or threatening behavior. All right. And you need to take anger management and cognitive behavioral classes. There are some free classes that you can take. All right. Sounds like this really got out of control and shouldn't have. Okay. So, is there anything else I need to order?
Nothing to keep Your Honor.
Not to order, no, Your Honor.
All right. Sir, you know, you have a GED. You got some skills. There's restaurants that can use your skill. There's lots of things. You can go over to LCC and have free college. Did you know that?
No, I did not.
Well, how about that? They have a program called Reconnect. You could get a free college degree. That would set you up for life. People can take away a lot of things from you, but they cannot take away your good name or your education. So maybe you ought to check into those classes at LCC and start to uplift your family instead of this continued homelessness. We do have some help available. I need you to unlock that, and I'm going to make a note to probation that they should work with you in regards to homelessness. All right? Because there are some avenues, and I don't want to see you homeless. And the winter's coming, so let's use the next 6 months of okay weather to get you in a residence before the winter, okay?
Yes.
This probation is meant for your success, not your demise. It's up to you. Okay?
Yes, Your Honor.
So ask for the help you need, and so we can help you rehabilitate yourself, but you have to put in the hard work. Do you understand?
Yes, Your Honor.
All right. You have 42 days to appeal to request appellate counsel.
Nice. So on the record in the matter of the state of Michigan versus Rosemary Ferris, 172818.
It's officially afternoon. Good afternoon, Your Honor. For the record, Justin Barnett, appearing on behalf of Rosemary Ferris. State your name for the record.
Mary Ferris. All right, thank you. And thank you for dressing appropriately for court. But we need Mr. Mohammed back in here. Because I need to make sure that there's an understanding as it relates to the 1 year probation. Thank you, Gordy. All right, and counsel for the people, please.
Good morning, or good afternoon, Your Honor. Mohammed on behalf of the people.
All right, thank you. And so today is the date scheduled for the probable cause conference, and it's my understanding there's been a resolution, correct?
Correct.
All right. And so I just want to clarify before we begin the plea process, that there's a recommendation for 1 year probation. Is the intention for 1 year to be served, or is there an intention for 1 year early discharge per the statute?
Statute.
Right.
If she would be eligible under the statute, we would have no complaint.
Okay.
For the courts to correct at that time.
Okay, just wanted to confirm that. Also, this is MCL 750.3564 paren A, or is it 356 paren 4 paren A?
On my computer system, the way it was listed was 35648. Nonetheless, it is to Larceny $200.
Well, okay, but hold on, because your computer system, I think, doesn't throw the parentheses in. I just want to make sure that we're all talking about the same one, because sometimes things may not show up like that in our system. So I just want to confirm. 3564. That does not seem to be coming up, counsel. Is it 356A4? Or
I can look at MCL. My system must be having it labeled differently than the actual MCL. So I'm just looking for it right now.
okay, so you're talking about between 200 and 1,000?
Yes, it's a 1 year misdemeanor.
Okay. So
So Judge,
this is fine here.
That I am reviewing MCL 750.56, section 356 under 4A indicates that it's for property stolen in the value of $200 or more, or less than 1,000. So
Okay, let me see here. 356. Well, 356 paren 4 paren A. And I say that because there is also a 750.356A statute. So it's 356 paren 4 paren A. All right. And then 750.157 is a statute number 750.157 or 750.157W?
I will have to confirm that as well.
Okay.
That was just taken straight from our computer system for this type of a charge. However, it may be labeled different in the statute, so I'm just going to double check that.
Thank you.
So Judge, that would be the same as the last. It would be 750.157W paren
1 paren B paren 1.
correct.
Well, little 1. Yes. Okay. All right. Perfect.
And it's gonna be an attempt as well.
Yes, in regards to that.
Attempt?
Yes, that would be under an attempt. And the reason would be because of the factual basis is it would align close with what occurred in this event.
And this is going to be no contest.
Correct.
And the purpose is she does not recall the facts to support a plea to the list.
Yes, I believe this, I think around 10 years ago, so
9,
not my fault.
but close enough. All right. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that's been placed on the record.
Yes.
As to the amended charge of MCL 750.356 paren 4 paren A, larceny, $200 to $1,000, how do you plead?
No contest.
As to the amended charge of 750.157 W paren 1 paren B paren little I, attempt, how do you plead?
No contest.
Are you picking her up, Allie?
Yes.
All right. And you've gone over your advice of rights with your attorney, correct? I'm sorry?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be
Hey,
waiving
Devin,
some of those rights?
Coming down as a prisoner.
I'm sorry?
Yes, ma'am.
And you also understand the possible penalty as a result of your
Okay,
plea,
thank you.
correct?
Yes, ma'am.
And you understand that there's a recommendation for 1 year probation, no contact with the complaining witness, for restitution, if applicable, better decision-making class, and any other conditions or terms set by the court, correct?
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
Counsel, any objection to the court reviewing the police report for the factual basis?
No, Your Honor, we'll stipulate to the police report on the back of this.
All right. The court will indicate that after review of the report that the court does find there's a factual basis. Ma'am, your attorney worked out a very stellar deal for you. The court will accept your plea as knowing, voluntary, and factually accurate. And then, ma'am, the court will dismiss the original charges per the plea agreement. Ma'am, you're going to go over to probation. You're going to get all of your next steps. Counsel, you may coordinate the sentencing date with your calendar.
We're already hearing back in front of you on her other case on the government suspended on July 8th. I was wondering if we can do that the same day.
If that's what works, counsel, for probation, for having an opportunity to review that.
Okay.
Yes. Okay. All right. Bond and conditions are continued. Thank you.
Thank you, judges. Just for the record, I just wanted to be noted, the complaining witness did move to California. She's not residing in Michigan, but she was consulted in regards to this plea.
All right, thank you. If you can please forward the contact information to probation so that they can send her notice per the Crime Victims' Rights Act.
Understood. Thank you.
Thank you.
Your Honor, do we go to probation?
Yes,
Thank you very much.
you're welcome. All right, let's go on the record in the matter of the State of Michigan versus Stacy Donahue, 26750. And Detective, your name for the record, please.
Detective Sergeant Devin Geiger, Wyandotte Police Department.
All right, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you may proceed on the warrant.
On 6/3/2026, approximately 16:24 hours, Sergeant Morgan Gardaki responded to Son of the Beach Tanning, 27354 Street, in response to an emergency call involving a locked door and a occupant inside being unresponsive to staff members. Staff reported that there was a potential pill addiction, and the individual had slurred speech and was not responding to their knocking on the door. Officers arrived and were knocked on the door, received no answer. Officers were concerned for the safety of the individuals as well as the staff. Staff provided permission to force entry into the room. So at that point, that officer or Sergeant Gardaki opened up the tanning device and located the individual inside, Stacy Donahue, unresponsive. After some urging or some calling out to, she responded. Was provided clothing or options to make herself presentable. It was at this point the officers asked if she had taken anything. She reportedly stated that she may have taken Xanax, which she was not, or alloprolazine, which she was not prescribed, in THC. Officers asked if they could get her ID out of the purse, which she confirmed. She did state that she may be transporting Suboxone that she had in her purse, but it was not being transported properly. At this point, Officer Gardaki located inside her purse in this bottle approximately 8 bindles. Oh, at first he saw a straw with white powder on it, which raised this concern that was a legal substance inside this pill bottle. There were 8 bindles that were eventually tested and returned positive for fentanyl. There was a total weight with packaging approximately 2.14 grams. There was also a pill that was later identified by drugs.com as alloprolazine. At this point, there is no criminal history for Ms. Dunning.
All right, thank you. Upon examination of complaining witness, I do find the offense charges committed. There's probable cause to believe defendant committed that offense. Counsel, your appearance, please.
Good afternoon, Your Honor. Your Honor, John Goldpork, P30758, on behalf of Ms. Donahue. Ms. Donahue, please put your name on the record.
Stacy Donahue.
Thank you. As to the arraignment, Your Honor, she stand mute to the charges, waive forwarding of those charges, and ask for the plea of not guilty be issued.
All right, and the court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you're unable to afford an attorney, you may ask for one. You may have one appointed to represent you. You also, ma'am, the court has also signed the petition in order for appointing an attorney for felony matters. You have the right to be presumed innocent to proving guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on June 11th.
Can we do the 18th?
It's not more than 14 days in South.
Does the 18th, is it? Yes, we'll do the 18th.
18th?
At 9:45.
9:45 a.m. And counsel as to bond.
Ms. Donahue is 35 years old. She is single. Presently, she lives with her parents in Brownstown. She's unemployed. However, up to about 2 or 3 weeks ago, she was gainfully employed as a vet tech. She voluntarily left that location to search for a better job opportunity. As she explained to me, she didn't like the way some of the animals were being treated. Not to get into the whole situation, but she voluntarily left that employment. She's presently searching for other employment. She has no prior criminal record. On the lien or on the record, it does show there was a no cross of a marijuana case back about 8 or 9 years ago. That's right about the time it became legal. That's what she informed me, it became recreational, where it was no. She's never failed to appear for any type of prior court appearances. As indicated, she has no other convictions. She's not on probation. She's not on parole. There are no immigration issues. We're asking for a personal bond in this particular matter. I've also given her directions on what steps she should take with respect to her situation once bond has been provided.
Okay. And so, Miss Donahue,
Yes, ma'am.
if you intended on having another job, don't you think you should have maybe looked for other employment before you left your employment you were at?
No, I think
I had plans to go back to another place, but I just haven't yet. It's only been like 2-3 weeks since I quit that place.
Well, why haven't you gone back to the other place that you were going to go to?
I just hadn't reached out to him yet.
Where was that other place?
South Point Animal Clinic or Animal Hospital in Allen Park.
Okay. And so again, ma'am, don't you think you would have wanted to have all that lined up so that you weren't going without income?
I have a little bit of money saved up, so I was just taking a little time off because I've been going through a lot lately. And so I was just taking a little time off, that was all.
All right. And ma'am, if you test right now, what is in your system?
Weed, probably fentanyl and Xanax.
Are you interested in recovery, ma'am? Any
Yes,
inpatient
I am.
treatment?
Yeah. I've never been.
That would be a great time for that, since she's not working right now.
I
And she
understand.
doesn't seem to have many of her own obligations, and she doesn't have her own residence.
Well, she does live with her parents. Sure.
I understand. I'm mean, living solely by yourself, being the only financially responsible person.
And that was one of the things I suggested to her, that when she is, bond has been conditioned, that she should be looking into treatment programs.
Are you currently on probation or parole anywhere, ma'am?
No, ma'am.
Have you ever failed to appear in court for any reason?
No.
Detective, would you like to address bond?
Just a request that no drugs or alcohol unless prescribed, and then just a bond to assure presence. There's a lack of criminal history here, so and she does appear to live locally somewhat. So just a bond to appear being a felony charge, 5,000, 10%.
All right. And so, ma'am, in 2023, it appears though there was an accident, a fatal accident.
Yeah, there was an accident, but nothing came about it. I wasn't charged with anything, or
You seem to have had a lot of accidents. You've had 4 in 5 years. All right. Here's what the court's going to do, ma'am. The court's going to order a $10,000 personal bond. The court's going to order you to be tethered to treatment through the Wayne County Jail. So that way, ma'am, you can get a jump start on your treatment. And we will see you back on June 18th. Not to possess or consume any alcohol or drugs that are not prescribed.
Okay.
Thank you.
All right. Thank you. Have a good day.
Good luck, Ms. Daniels.
All right. Let's go off the record.
All right. We're going to address the matter of Jayla Marie Stallard, who now goes by Wilson.
I'm sorry.
And we had talked about that when I saw her last. Miss Stallard was charged with felony larceny in a building and embezzlement from the American Legion in December of 2024. Those were charged as felonies. The matter was reduced to a misdemeanor, and the defendant was placed on a probation. Miss Ives must have really done some substantial arm twisting here to get this reduced to a simple misdemeanor under $200. She was placed on probation for 12 months, 91 days, credit 1, leaving 90 days to serve. I gave her a week, so I deferred to 83 days and some fines and costs. There's also $1,250 worth of restitution to the American Legion. That didn't work out. Daniel filed a probation violation petition, Daniel Frazine, her probation officer, last August. It's alleged that she failed to report on a monthly basis, failed to pay fines and costs or restitution, failed to test on demand, and failed to participate in treatment. Basically, we just lost track of her. An arraignment was set for August 15th, and the defendant didn't show up, and a bench warrant issued. And she got picked up somewhere before May 28th. She had been in jail in some other jurisdictions. And Rush County, Indiana. And then she got released from Indiana. Apparently, we didn't have a hold on her. And she got released in December of 25 and was living her life in LaGrange and working. So I canceled her bond and set the matter for a probation violation hearing today. And your attorney, Rhonda Ives, is back with us, and she's been out to the jail to meet with you, which I appreciate. It's my understanding, Ms. Ives, the defendant is going to admit to at least part of these violations.
Yes, Your Honor, she's going to admit that she failed to appear for probation as directed.
Is that true, Ms. Wilson?
Yes, sir.
All right, I told you this at your arraignment. Let me repeat it here today. You have a right to have a hearing in this matter where it must be established by at least a preponderance of the evidence that you violated these terms of your probation. And as I told you at the hearing, you'd have a right to have your attorney present, and she's here with you. She was your original attorney that worked out this very favorable plea agreement. By entering a plea to that violation, you'll be giving up your right to have a hearing on the violation where it must be established by a preponderance that there was a violation of your terms of probation. Frankly, these aren't going to be real hard to prove. We just lost track of you. So are you here admitting that you violated your probation by failing to report from sometime in August until you got picked up again in May of 2026.
Yes, sir.
All right. You had gone to jail in Rushville, Indiana. And I don't remember if you told me what that was for, but whatever you had in Indiana is done. Is that correct?
Yes, sir.
What was the charge in
Well,
Rushville?
the original charges were stolen vehicle, possession of meth, but none of the stuff that they had found on me was meth. The ending charges ended up being I did 4 months for possession of marijuana.
So that was the charge?
Yes.
Possession of marijuana?
Yes. And I completed all of that.
And if what you told me was correct, you were released from there in December of 25 and then just went back on with your life. Got a job, got a place to.
Yes, yes.
All right, let's go to Daniel's recommendation. This was not a very successful probation. Is we simply revoke the probation and impose the deferred days of jail. At that time, there were 81 days left. She's got some additional credit since she got locked up.
Well, I wrote 81, but I believe technically after the judgment, it says 83.
All right, it was 83 that were deferred.
Right.
How many days has she
And
been?
she got 8 days credit today, so it would be a 75 remainder.
What's your recommendation? We simply revoke the probation, reserve the restitution, and impose the deferred jail days?
Yes, Your Honor. And I will just say that when I contacted them back in August on 25 Roche County, they said that her charges that they were still working with were at that time possession of meth, receiving stolen property, possession of syringe, and trespassing charges. They also stated that she wasn't going anywhere because of a failure to appear for their court, as well as being on probation and absconding from that for my probation. And that was the situation. So kind of like repeat behavior is kind of what it looks like down there. So I'm guessing that's why she got 4 months for a marijuana charge. If that was the result of it, I didn't call and find out for sure, but yeah. And then she got out the end of last year and had her name changed. She didn't update her change. She just went on with her life. So I don't get the police reports, but I'm assuming since the court gave her that much time that it must have been a serious offense, and I would just defer to the court, but I would say give her the balance.
All right, Ms. Ives, what's your thought here?
Well, Your Honor, my client would like you to consider allowing her to continue on probation. And this would be why. She really didn't get very far when she got released back in July. She hadn't had any substance abuse treatment. Had relapsed back with marijuana, was in Indiana. It's still illegal in Indiana. And although there was other various charges, she had pled not guilty to them. She ended up pleading guilty, was sentenced, and obviously not in Michigan for approximately 4 months. When she got out of jail, she realized she really needed to keep substances out of her life. Since she's been out of jail and she's been living in Sturgis with her in-laws, I think it's Sturgis, correct? Yes. She started her own program that she has maintained, and she's been going to Celebrate Recovery on Fridays. She's been doing the Sturgis Missionary Church, the group on Sundays. And she's also, except for a couple weeks prior to being incarcerated because she'd gotten a job and was working on Sundays, or on Wednesdays, she had been going to a recovery group for women on Wednesdays. Was it for just for women?
Yes.
On Wednesdays at Destiny Church. And she really was trying to put, I think, you can't help anyone else until you help yourself. And I think she was really, in my opinion, just based on everything she's told me and what she's learned through the course of going through meetings, that she's had to take this one day at a time, focus on treatment. She was able to obtain an employment. She just got her first car in a long time. So she's got a valid license. It's validly plated. It's got valid insurance on it. she has an employer that they're keeping her position for her, at least right now. She's got her first paycheck, and from that paycheck, she's willing to, put, I don't know how much her paycheck is, but she said she'll have at least $50 that she could pay towards the restitution immediately. She would like the court to consider you to allow her a chance, even if it's a short-term probation where she could pay off the restitution, show that she's a different person now. And I know that's a lot to ask for, but essentially, a lot, kind of happened rather quickly. And I know that I think the outcome for her was a good plea. And I think she understands that that was a benefit to her. And she also knows that the restitution had to be paid, but she was really in a position that she couldn't do much. Just based on her mindset when she was released from jail, and then obviously her subsequent incarceration. And so that brings us today, but she would like the court to consider giving her an opportunity to show you that she'll pay the restitution in full and that she'll comply with Mr. Presiden's reporting requirements and obligations that she would have with his office.
All right, thank you. Ms. Stallard, Ms. Wilson, or Ms. Scare, I'll go with Ms. Wilson. What do you want to tell me?
I mean, a lot has changed for me since August. I've been sober since August, going on almost 12 months, and this has been a roller coaster for me because it's been up and down. But I'm a grandma now, and I'm getting ready to be a grandma 3 times over, and I love my job, and I'm happy that I finally got a vehicle for the first time in 2 years in my own name. And I'm just willing to do whatever, be at the mercy of you. I mean, I understand that this has been a pattern, but this time I mean, it's different for me. I've been doing this on my own since August. And
why didn't you contact Daniel when you got out of jail?
I know it's not, I mean, it's excuse after excuse. I wanted to get established. I wanted to get a place. I wanted to get a car. I wanted to show you that I wasn't the same F up that I've been my whole life. And I just wanted to show you that I really was honestly going to start making payments as soon as my checks started coming in. And I just wanted to show you that it was different this time than any other time. Me just telling you whatever you wanted to hear.
Which I think is what you've done. I think you got a big, large streak of con man in you. This was a bad crime. You stole all this money from the guys at the American Legion who trusted you with that job. You didn't just steal it once, you stole it multiple different times. Then you went into the building, you drove in there at night with your car, went in there, stole some stuff, lied repeatedly about it, till you finally admitted, it wasn't me, it wasn't my car, that's not me. Well, it was you on the video, it was your car or somebody's car you were borrowing, and finally you admitted it. You remember, it was in the old courtroom. All the guys from the Legion were in there. And it was in part because of them that you got this sweet plea agreement. This was a felony. It was a clear felony. It was a breaking and entering, or at least a larceny of building. You went in the building at night and stole from them. And when you were working, you would steal money from them and the lottery. There were probably 8, maybe 6, at least different incidents where you stole money. So it should have probably been a felony. You wouldn't have gone to prison, but you would have had a felony. So it was instead a 90-day misdemeanor. So I held a large portion of jail over your head. And the guys from the Legion were very generous toward you, and you paid them back by doing 0 on your probation, going to another jurisdiction with a needle in your car, going to jail, getting out of jail, never calling your probation agent or doing any effort to repay it. So I don't know who you are now. It seems like a better person you were then, But the person you were there then was not very good. And you didn't do anything that I asked you to do, ordered you to do. So you've earned this. I'm going to order 93 days jail credit. How many is that? 93 2, 93 minus 75 is 18 days jail credit. Leaving 75 days jail to do. You'll get 5 days a month good time. If you're on the path that you're on with your own self-motivated recovery, I don't need you on probation. But this offended my sensibilities. You got a super sweet plea agreement. You got a very generous sentence by me, and you pay me back by this. So I'll reserve on the restitution, which was $1,200. So if all those things are true, $1,250 restitution to American Legion. So you'll still have an opportunity to pay it back, and your probation is revoked. At which point you can really start fresh. I won't be supervising you, won't be looking over your shoulder, but I told you what was going to happen at the time of the sentence, and it just happened. I'm disappointed, but I'm, I guess, encouraged that you're in a better place today than you were then. But you got 75 days to do, and you still owe $1,250 in restitution to the American Legion, and your probation is revoked. So when you're done, we'll be off your back. All right, good luck to you.
All right. Good luck to you. Don't go away just yet, ladies and gentlemen. I'm trying to get myself, oh my God. I'm trying to get myself organized here. Bear with me. Doing the thing. Hey! How you doing? Bella says hi also. What are you barking? Where are you? Oh, hey. He's right here. Say hey, Bella. Hello. That's all we have right now. Okay? So later on tonight, there's going to be a premiere. Tonight's premiere is a longer premiere. So I'll go ahead and we're going to get a little bit of a taste of it in just a minute. But it's a Simpson case. I have it labeled here as Simpson Norman versus Stanford trial. I'm 90% sure it is a really long landlord-tenant matter from earlier this week. So it's a tad over 2 hours long, ladies and gentlemen. Just a tad. So, chat, you have options. While we're sitting right here, right now, chat, do we start this premiere at 7:30 tonight, or do we start it at 8:30 or 8 p.m.? Do we start at the normal time, or do you want to start 30 minutes earlier because it's a little north of 2 hours? That's the $8 million question. And while you think about that, please. Let's start some credits, shall we? I have some very important people to thank you. Integrationing. Nina out of the blue, absolutely top tier. Thank you, thank you, thank you. All of you, thank you. As a matter of fact, I was just talking to somebody about the membership ordeal. Anyway, CE, thank you so very much. Cosmic Shield. Who was just telling me about you? I was just talking. Was it Denisha? It was Denisha, wasn't it? Yeah, it was Denisha. I hope you enjoy uni, Denisha, and come back and watch anytime you have time between your studies. you people out there, you don't worry. We don't do membership here. You don't have to donate. We appreciate every single view, every single like, every single subscription. That's just the way it is here. We're saying 7:30. Yes, 7:30 p.m. Central would be 8:30 p.m. Eastern. I mean, if you really want, it is a premiere, and I can make it 8 p.m. Eastern time. 8 p.m. Eastern time. That would make it 7 p.m. Central time. I don't do math either. Math Girl's not here. We depend on Math Girl for these things. I think it'll probably be 7 p.m. Central Time, 8 p.m. Eastern for the premiere tonight. And what is that premiere, you may ask yourself? Well, ladies and gentlemen, stay tuned. I don't know why there's random music playing in the background at my house right now. That is not a thing I did. Oh my dear goodness. I'm not even on the screen. Who's in charge of this ramshackle operation anyway? What
Susie Norman
Oh.
versus Gil Stanford.
What's this? It's a preview of tonight. We're not watching all of it. We're watching like 10 seconds of this. And then we're going to preview tomorrow night's premiere.
State your names.
It's all about the dinosaur.
Gil Stanford. Okay. Mr. Stanford, what is your claim at this?
Damages to the property.
How much are you claiming?
How much?
This is just a taste of what's coming in with the premiere tonight. Look at the papers he's pulling out of that box. Oh, and the box. That old printer cartridge box, ladies and gentlemen. Wow. He's keeping all of his important papers in an old printer cartridge box. That's straight landlord class right there.
I'm claiming
And
is
landlord
$7,138.17. Lesser deposit $1,050. So the balance $6,088.17.
Ms. Norman, your position on this is all of that was waived in the previous proceeding.
And also my security deposit, that's an incorrect amount from my standpoint.
But as I was to understand this from before, and I certainly will have a trial on the issue, but I don't think it's going to be necessary. He was going to keep the security deposit, but there were going to be no other claims.
No.
No. Go ahead.
At 7 p.m. Central
What
tonight,
did you
8
think
p.m.
was gonna
Eastern,
happen
I
with
will
the
not be
security
stepping
deposit?
all over this. Judge
Well,
Simpson
I
has
did
a lot of questions.
Day in October of
A lot of questions. And he gets deep into the situation. And it is as interesting as it seems already. Tomorrow night, we'll be starting at the same time, 8 p.m. Central. And then there'll be this.
Morning.
All I can say is
All right, looks like we have everybody here that we need, so we'll go on the record. This is in the District Court of Greenwood County, Kansas. Case is entitled in the matter of the marriage of Betty Jo Barg, petitioner, and Jesse Dean Barg, respondent, case number 26 DM 13. Would counsel announce appearances, please?
Thank you, Your Honor. May it please the court, Riley Burrows appears on behalf of petitioner Betty Bark, who also appears via Zoom in my office.
May it please the court, Mary Ann Shirley on behalf of the respondent Jesse Barg, who appears from a different location by Zoom also.
So I'm gonna throw mud on this situation real quick. Oh my goodness, that's the wrong thing. The hero of the story right here with the fabulous hairdo, the most fabulous hairdo we've seen all week long, is the dear old dad for son one right here, who is not with dad right now, and son number two, who has dad's same name and is currently with dad, but maybe he shouldn't be right now. And there's a whole situation that we're going to go through with Judge Crum concerning that tomorrow night at 8 p.m. Central Time. And it's a messy one. It's an interesting one. It as with all of these, yet another cautionary tale from the court system. And we'll get to see it from the gallery. Ladies and gentlemen, I am your lone Wafuso. I bring you these court cases, and I will see you next.